Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Lisa Mosby, your host, and today we're discussing bankruptcy litigation in Texas and how Chapter 11 can function as a strategic tool in commercial disputes. Bob, thank you so much for joining me today.
Oh, good to be here.
You know, Bob, in the context of commercial litigation, when does a dispute begin to intersect with bankruptcy considerations?
Well, it's usually a defendant that is contemplating a bankruptcy filing. So, it can be at the outset. It can be if the litigation is going badly, or there are additional lawsuits that are getting filed. If the litigation is really starting to hamper the defendant's cash flow to the point that they really do need a sort of a breathing space, if you will, from the automatic stay in bankruptcy. Those are factors to consider. It's also the structure of the defendant. A lot of bankruptcies are what are called, the entity is called a single asset bankruptcy remote entity. It's fairly common in real estate development or real estate investing, where there's a single entity that is formed to own a particular project. And the reason for that is if the organization has to put that property into bankruptcy, it's just one entity that's going into bankruptcy. It doesn't impact the rest of the organization directly. So, those are considerations to take into account.
And you mentioned automatic stay. Can you tell us what that is and how the automatic stay in Chapter 11 cases alter the leverage between parties who are already engaged in state or federal court litigation?
Sure. So the automatic stay is Section 362 of the United States Bankruptcy Code, and it provides that the filing of a bankruptcy petition, but the filing of a bankruptcy petition, usually a Chapter 11, it brings the automatic stay into effect. In other words, there is automatically by statute a stay imposed on all actions against the debtor or the debtor's property. That in broad terms. There's a bunch of exceptions, but in a general sense, say you've got a company that's the target of multiple lawsuits. If they file a bankruptcy petition, the Chapter 11, all those cases stop. Then the creditors, the plaintiffs in the lawsuits, they can, try and get the stay, relief from the stay. That's probably not, if in the case of an ongoing lawsuit, that's probably not going to happen unless, sometimes you see it in tort cases where, a company's subject to a lot of tort cases and maybe they're like right before trial and they decide to file bankruptcy. And the plaintiff may file a motion for relief from the stay, but agree that they will only look to insurance proceeds to satisfy any judgment. And I've seen bankruptcy judges grant those kind of stay motion or relief from stay motions. The other effect is, and you see this with respect to foreclosures, because that it's an action, even non-judicial foreclosures, it's still an action against the property of the debtor. So the automatic stay kicks in to stop a foreclosure, which in Texas is the first Tuesday of the month is when foreclosures are held. So you see a lot of bankruptcies filed right around the first of the month.
Wow. When representing creditors, Bob, in a business bankruptcy, what litigation issues tend to become central early in the proceeding?
It depends on how the case got filed. There may be, there's a fair amount of litigation over bad faith filings. In other words, the creditors trying to get the bankruptcy case just dismissed, so they don't have to, trouble with the bankruptcy court. And sometimes those are successful. The other factors are, to what extent is your lawsuit going to be just kind of on ice until a plan gets confirmed? Because typically in Chapter 11, the debtor has a period of time where the debtor is the only party that can file a proposed plan of reorganization. That's called the period of exclusivity. And if it's not a prepackaged bankruptcy, in other words, the debtor hasn't done pre-bankruptcy planning and already have a plan put together, and they're just ready to go. It could be, the initial period of exclusivity, I believe, is 120 days, and it can be extended on motion by the debtor. So if you're a creditor, you may be in there tied up for a while, depending on what's going on with the debtor's bankruptcy. Another factor is this really a business that's capable of being reorganized? I've seen a lot of bankruptcy cases where they claim they're going to reorganize, and after a year and a half, the case winds up getting converted to a Chapter 7 because the debtor really has no prospect of reorganizing. I think from a creditor standpoint, you would probably rather get to that point sooner rather than later if it seems to be inevitable. There's also a distinction whether you're a secured creditor or an unsecured creditor, because secured creditors are in a much better position in the bankruptcy than unsecured creditors. Particularly if your collateral is worth, has a lot of value. I've been representing creditors where, particularly for equipment, you've got you're the secured creditor. Your collateral is a big piece of equipment that's worth maybe $5-6 million bucks, and if you can show that your debt is more than the value of the equipment, because equipment values depreciate pretty quickly, then a lot of times, or I say a lot of times, not infrequently, we've been able to get relief from the stay, and we just accept the collateral back in satisfaction of the debt, and then we're basically done with the bankruptcy.
Sure, makes sense. So how do adversary proceedings within a bankruptcy case differ procedurally from traditional commercial lawsuits?
Not really all that much. I mean, because there are the federal rules of bankruptcy procedure, and the 7,000 series of those rules apply to adversary proceedings. And for the most part, they simply adopt the federal rules of civil procedure. So you're operating under basically the same rules. There are some variations. For example, in most cases in bankruptcy court, you're not going to be permitted to have a jury. There are possibility, it's extremely rare for a bankruptcy judge to hold a jury trial, though it's not an impossibility. Or, particularly if you're the plaintiff, you may want to have it's called the withdrawal of the reference. And what that means is the bankruptcy court is like a division of the district court. And there's a standing order of reference in every district that automatically refers bankruptcy cases to the bankruptcy courts. Well, in certain cases, you can file a motion to have the district court withdraw the reference for that case. So in other words, the case comes back up into district court, and now you're in front of a district judge where you have, greater rights to a jury trial.
I follow you. Bob, in disputes involving secured lenders or guarantors or multiple stakeholders, how does bankruptcy court reshape allocation of risk and recovery expectations for those folks?
For secured creditors, you're generally in pretty good shape so long as your collateral has a lot of value. There are circumstances where a secured creditor can be, it's called crammed down. In other words, under a plan of reorganization, if certain requirements are met, you can, involuntarily be have your recovery reduced from what it would be outside of bankruptcy court if you foreclosed. For guarantors, the uncomfortable fact is that filing the bankruptcy petition doesn't protect them at all. In other words, the fact that the borrower, say it's an entity, is now a debtor in bankruptcy means that a lawsuit against the borrower can't go forward. But if the principals of the company have guaranteed the debt, the fact that the borrower is in bankruptcy does not stay actions against them. So that's, that certainly factors into it. They have, now I guess in rare circumstances, I've seen bankruptcy courts determine that it's so important to have this particular guarantor involved in, running the debtor or reorganizing the debtor, that it is appropriate to extend the automatic stay to them for, a guarantee obligation, for example. But that is relatively rare.
Okay.
Now, a lot of things can be done in the context of a plan of reorganization, and related parties related to the debtor have gotten releases in bankruptcy plans. In other words, the claims there's claim treatment that's specified, and as long as the debtor performs under the plan, consummates the plan, then those claims, whatever it is they get under the plan, that's it, and they can't sue anymore. And sometimes you'll have guarantors or other related parties who also get a release. Now there can be litigation about whether that's appropriate or not appropriate, and there's a lot of case law on when non-debtors can get released in the context of a plan. But that is something that has happened.
And then, Bob, from a strategic standpoint, how can the prospect of a Chapter 11 filing influence negotiations even before a petition is filed?
That's kind of a two-edged sword, because one of the things, say you're in a lawsuit with an entity and they start talking about bankruptcy. If you settle with them because you don't want them to go into bankruptcy, and then 89 days later they file bankruptcy anyway because they've got other issues, well, your settlement money can get clawed back by the debtor because it's a preference. So that's kind of a downside to it. It may provide a disincentive to settle at that point. On the other hand, if it looks like the debtor can actually make a go and stay afloat, if you settle with them rather than letting them go into bankruptcy, that very well may be a better option and may support you discounting what your settlement demands are to get it done, and not go through potentially years of fighting in the bankruptcy court.
I suspect the challenge there would be to know their financial situation and if they can be completely honest with you so that you could make that decision whether you wait it out or settle.
That's true. Yeah. And, so you can certainly ask for information. It can certainly be provided under a non-disclosure agreement or a protective order. But you have a certain amount of that you're going to be taking the information on faith, because you don't have, a team of auditors ready to go in there and comb through their books. So yeah, that's a good observation.
So, Bob, how do courts evaluate claims of fraudulent transfer or preferences in the context of business disputes?
So preferences are pretty cut and dried. If you have received a payment within the 90 days before the debtor filed bankruptcy, it is presumptively a preference. If the debtor was insolvent at the time they made the payment, and if that payment allows you to receive more than you would have had the debtor liquidated, gone into Chapter 7 bankruptcy. Now, there are some exceptions to it. There's a new value exception. So you say, well, yes, they did pay me these back invoices, but I continued to do business with them and I sold them more stuff on credit. You've got that argument. You've got the ordinary course argument. It's, well, yes, every 30 days they pay me on stuff. And, we were having a dispute about this, but they paid in the ordinary course. So you can get away from preferences on that ground as well. Fraudulent transfers are a lot more fact intensive, just because the circumstances under which that can be applied are widely varied. And there are basically two kinds of fraudulent transfers. There's actual fraud and there's constructive fraud. Constructive fraud, you look at a bunch of factors. In all of them, the debtor has to have either been insolvent at the time it made the transfer or became insolvent as a result of the transfer. But you just see circumstances where, one corporation files bankruptcy and another corporation is basically, just before that happens, another corporation is formed and it takes over the business and is operating the business with the same principals in the same leased space with the same equipment. You're going to get a fraudulent transfer claim out of that. So preferences, preferences get filed all the time. They are almost always resolved through settlement, usually somewhere in the range of 50%, 50 cents on the dollar. It can be more, it can be less, depends on how clean it is. Fraudulent transfers are a whole different ball of wax. And the downside for both sides in terms of litigating those is the prevailing party does not recover attorney's fees. So if you're, bankruptcy, if you're counsel for a bankruptcy trustee or a debtor in possession, and you've got a fraudulent transfer case that's not really involved that much money, and it's going to cost you $150,000 to prosecute it, you may really think twice about whether you're going to bring that case.
That's a good point. That's a really good point. When parallel litigation is pending in another form, how does coordination with bankruptcy proceedings affect overall case management?
Well, the automatic stay would, assuming the debtor is the defendant in other cases, the automatic stay is going to kick in and stop those. Now, the automatic stay does not stop litigation where the debtor is the plaintiff. So you may have a circumstance where the debtor is the plaintiff in a case, and that litigation will continue. And so there does need to be coordination between bankruptcy counsel and the counsel that's prosecuting the case in, say, the other jurisdiction, in terms of what's going on, because that litigation is probably going to be a substantial factor that needs to be addressed in the bankruptcy case, in the plan of reorganization, for example. The other situation is you can remove cases to bankruptcy court if they are at least related to a bankruptcy case. And there's a lot of litigation that goes on about that, because it's a lot. Say you remove a case from state court to bankruptcy court because the debtor filed bankruptcy, or one of the parties filed bankruptcy. You see this like if there are multiple defendants and one of them files bankruptcy, then you can remove the entire case to bankruptcy court. Well, there's doctrines in bankruptcy tied to statute for either abstention. In other words, the bankruptcy court is going to abstain from deciding the case and is going to send it back to state court, or remand. And it's easier to get a bankruptcy case remanded than a case that was removed on the basis of bankruptcy jurisdiction remanded. It is to get a case, for example, in regular district court that gets removed on basis of diversity of citizenship, for example. So there's often a lot of litigation about, can the case stay in bankruptcy court? Is it mandatory abstention or is it permissive abstention? And there's different factors that go into that calculation. So that is some of the procedural wrangling that can happen if there's other litigation that's out there once a bankruptcy is filed.
And I think that's where we'll leave it today. Thank you so much for your guidance through this. There are a lot of nuances, and I encourage folks, if you are listening, take advantage of the intellect that we have in the room today. That's it for today's episode, the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Robert and his firm's work in business and intellectual property litigation, visit carterarnett.com. Thank you so much for listening. And remember to like, subscribe, and join us for the next episode. We'll see you there.
Okay. Thanks very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.